Members of the jury, in this action, Brown is the plaintiff and the defendant is Taylor and Company, Incorporated. Plaintiff seeks to recover damages from the defendant in the sum of $4,596. That is made up of the item of principal of $3,900 and interest of $696. The burden of proof in this case is upon the plaintiff, who must prove his case by a fair preponderance of the credible evidence. You are not to go outside of the evidence in determining what the facts are in this case. Of course, you are allowed to use your common sense and apply it in determining what the facts may be. Nevertheless, you must take the facts as they were testified to by the witnesses, and the law as laid down by the court. You are bound by the law as laid down by the court. The credibility of the witnesses is for you to pass upon. It is for you to determine exactly where the truth lies. If you believe that any witness called by either side has willfully testified falsely to a material fact, then you must disregard that witness's testimony upon that fact. If you believe that a witness has willfully testified falsely in part, then you may entirely disregard the testimony of that witness, or take so much of it as you believe to be true. I do not say that any witness called in this case has willfully testified falsely in part, but it is a rule of law that must be explained so that the jurors may apply it if it becomes necessary. As I said before, the burden of proof to prove the cause of action is upon the plaintiff. Plaintiff must prove his cause of action, and by a fair preponderance of the evidence. If the evidence is equally balanced in your minds in such a way that you cannot tell exactly where the truth lies, then the plaintiff will not have sustained the burden of proof, and consequently your verdict would have to be for the defendant. The issue is, after all, a very simple one. You have heard the version which the plaintiff has given you of the facts that he contends to be correct. On the other hand, you have heard the version of the facts as related by the president of the defendant corporation. Plaintiff asserts that during the middle of September 1904, he went to Mr. Taylor, that he had a talk with him at the place of business of the defendant company, that he told him that he had a new hotel which was about to open, and that he would be able to bring about the sale of certain rugs to that hotel. He testified that Taylor said, in substance, that he would be glad to have him act as a salesman, but that he suggested to the plaintiff that he bring his parties down so that he might meet them, and then that there was a discussion with reference to who should sell the goods. Mr. Taylor stating that the sale should be made by the defendant. In the course of the talk, it is asserted by the plaintiff that Taylor made the statement that he would pay a commission of 25% on all sales to the management of the new hotel. It is asserted by the plaintiff that solely through his activities, solely the introduction by him and based upon the agreement which he asserts he made with the defendant, he is entitled to certain commissions. He says the defendant sold to a hotel merchandise to the value in all of $16,800. It appears from the records and the evidence that there was a check delivered on the 10th of October for certain merchandise. How's it?
$180. I don't think it was that much.
1, 2, 3, 4, 5, 6, 7.